All right, let's unpack these proposed labour law amendments with an analyst. Labour law analyst Tony Healy joins us now for some analysis. Tony, thanks very much indeed for your time. It's a pleasure talking to you. You heard that soundbite from Zwelinzima Vavi, the General Secretary of Saftu, and clearly his key gripe with these amendments is these new amendments insofar as dismissals is concerned. And in fact, the labour law proposals as a start do deal with specifically dismissal and retrenchment procedures. How do you see that?
Good afternoon, Michelle. Yes. First of all, NEDLAC has been discussing these amendments for about 3 years now, and they're culminating with a submission to Parliament, probably the end of this month or the beginning of November. But to your point, and I heard Mr. Vavi's comments on the procedural fairness aspects of discipline and dismissal. You know, the fact of the matter is, if Mr. Vavi were to just go back and, for example, read the explanatory memorandum of the 1995 Labour Relations Act, he will see that when it comes to procedural fairness, that disciplinary hearings were meant to be conducted in a non-legalistic, expedited way. Even Schedule 8 of the Labour Relations Act, which deals with disciplinary hearings and procedural fairness, talks simply to the fact that there must be an investigation, the employee must be given an opportunity to be heard, and then a reasonable decision needs to be made after that. But what's happened over time, Michelle, is employers have kind of adopted a kind of Criminal Procedure Act approach to disciplinary hearings, overcomplicating them, having them run for too long, having written findings that go on for pages and pages, so much so that we have a very well-known Labour court judgment, the so-called Avril Elizabeth Holmes case, where employers are criticised for being too formalistic in disciplinary hearings. So that's really what this particular amendment relates to, is just trying to simplify discipline and dismissal, and then the CCMA or bargaining councils will be the ultimate arbiters of whether that decision was fair or not.
I see. But to Zwelinzima Vavi's point, Tony, does this not pose a threat to the stability and the work security of an employee that is involved in a disciplinary hearing?
I don't think so, Michelle. You know, at the end of the day, all decisions made by employers at company level need to have stickability at the CCMA. They have to be able to withstand scrutiny at the CCMA. So I don't foresee at all that a simplification of disciplinary hearing processes, really back to what they were always intended to be in the first place, will, for example, embolden employers to dismiss discriminately, because they will still know that any decision they make at company level will still need to withstand the scrutiny of a commissioner at the commission or at a bargaining council.
Yeah, sure. So employers know that should this case end up at the CCMA, they would have needed to cross their T's and dot their I's. But I just wonder, Tony, whether there is some comfort for employers who perhaps are not behaving as they should, with the notion that not everyone is going to take the process to the CCMA.
Well, I think if you look at the numbers, Michelle, you know, you get, 800-900 referrals of cases to the CCMA across the country every day. Probably about 500 to 600 of those are alleged unfair dismissals. And those numbers are growing. So employees, you will hear from the CCMA that employees are increasingly aware of and conscientized with regards to their rights in terms of, for example, challenging unfair dismissal. If you speak to those that are drafting or, you know, the laws themselves or the amendments themselves, and if you speak to the CCMA itself, they will tell you that one of the concerns they see in unfair dismissal cases and discipline is the fact that employers manage disciplinary processes far too legalistically and technically, and it was never intended to be that. It was intended to be a process where an employee is made known of a complaint, the employee is given a fair opportunity to explain themselves, and the employer thereafter is required to make a reasonable decision regarding whether the explanation is satisfactory or not, and if not, what would an appropriate sanction be, knowing that ultimately that those decisions may well, and in all likelihood, will be tested and reviewed at the CCMA.
Yeah, that's really important context. Hundreds of cases taken to the CCMA every day. So yeah, you're absolutely right. Employees clearly are aware of their rights. The point I think Zwelinzima Vavi was making is that he believes these proposed labor law amendments will ultimately pose a risk, pose a threat to work security, to employment security for workers. On the balance of all of the facts you have, Tony, do you agree with that in any way?
Well, I think you need to, I think we must understand from whence it comes, that comment. Mr. Vavi is a head of an organized labor federation, and one would expect Mr. Vavi to say that, and he's perfectly entitled to be of that view in his role of protecting job security of union members. But let's not forget, only the job security of the employed. I mean, the fact of the matter is we've not had major changes to the Labour Relations Act for a number of years. And I think it's right. I think we should be saying to ourselves, is the Labour Relations Act still fit for purpose? Mm-hmm. For example, we sit with 4 out of 10 South Africans being unemployed. Now, Mr. Vavi doesn't speak for them. If there is indeed ultimately a slight loosening of the regulation around employment practices, I mean, just talking about a slight loosening, then maybe that will encourage employers to be more willing to employ without contemplating the fact that dismissal is, in fact, a really laborious process. So, even with these amendments, I can assure you, Michelle, South Africa has amongst the most so-called progressive and employee-friendly regulations in the world. And what is being proposed presently doesn't necessarily dent that in any significant way.
Yeah, and the important thing is to make a dent in those unemployment numbers, absolutely. Tony Healy, let me thank you for your time this afternoon. Tony is a labour law analyst as we look through the proposed labour law amendments.